Good afternoon, everyone, and thank y'all for joining us. My name is Mark Hefner. I'm the landowner advisor for Braun and Gresham and for Plateau Land and Wildlife Management, and I'll be moderating today. Owning land in Texas can be complex, and part of my role as the landowner advisor is to help you navigate that complicated process. Braun and Gresham is a law firm that specializes in dealing in those complex issues, from everything from real estate to conservation strategies, easements of all sorts. So they're known for that and specialize in it. Our sister company, Plateau Land and Wildlife Management, helps folks with ag applications, wildlife management plans, and there's also a team of biologists that can certainly help you understand your property better. So today I'd like to introduce Cassie Gresham. She is an attorney and counselor and be doing the presentation. Cassie and I have been working together for years, helping landowners out in all types of interesting situations. But one thing I can say about Cassie, she's always here to help you. She never turns anybody down, and if she can't resolve it, she will point you in the right direction, and we will help you one way or the other. So today we're going to be doing something a little bit different. A lot of times these are just a one-way communication type deal. We're actually going to allow you to communicate directly with Cassie if you choose to do so. If you want to verbally speak, please go down to the bottom of your screen or look around your screen, use your mouse and look for this little microphone, and it has a slash through it. You can unmute yourself and actually speak directly, which is fine. You can also use the Q&A. Just type in your information or type in your question. I'm going to be monitoring those and we'll be able to read those out to Cassie. So again, either way works for us. Cassie can jump in. And then let's see what else. I think that was all there. One point that I would like to make is that these are going to be recorded. So if you have something that's confidential or that you don't feel comfortable speaking in a group about, then please know that we're going to record these. You can come back to them, but also you're going to get our contact information. You can communicate actually directly with Cassie, or you can come to me as a landowner advisor, and we can kind of have a general discussion about where we need to go with it. So keep that in mind as you're talking. If you present a question to me via the Q&A, unless you tell me otherwise, I'm going to read that out loud. It will be anonymous. I won't use any names. It'll just be your question. We've also had a question or two submitted beforehand, so we're going to be addressing those. And I think that's really it. So again, at the end of the presentation, you'll have our contact information. Please don't hesitate to reach out. And I think that's all. Without further ado, please, I'd like to introduce Cassie Gresham.
Welcome, everybody. Good to see everyone. I see several people in attendance that are former clients or people I've met before. So glad you're all here. Don't feel bad about interrupting me at any point. If there's any questions that you have, I am happy to answer those. Unmute yourself, put them in the chat, and we'll answer them as we go along. But today I just want to talk to everyone about how to protest your property taxes. You've all gotten your notice of appraised value, or will be getting it very soon. It's the time of year that those come out, and it's really important that you understand what you're seeing on your notice of appraised value and that you're timely protesting that. A lot of times I'm trying to help clients after they have failed to protest, and it's a lot harder to get everything done that they need done and try to help them protest their property taxes if we miss the deadlines. It gets harder and harder. So we're going to talk about kind of 6 different topics today. So the first one is, how do I review my notice of appraised value? We're actually going to walk you through a notice of appraised value. When should I protest? How should I protest? What is the Appraisal Review Board process? What are my options after the Appraisal Review Board process? And what if I fail to protest timely? So we'll cover all of those topics today. All right, so the first topic is, how do I review my notice of appraised value? And we have, this is an example of we've taken off the client information, but an example of a notice of appraised value that a client received. And I'm just going to walk you through this and show you. Every appraisal district does it a little bit different, but this is one from Bastrop. And this land market value tells me it's going to show last year's, and it's going to show what is proposed this year. And you notice that the total market value is $86,254. And this same number was over here in the ag and timber market value last year. So that should raise a red flag for you that something is wrong. Why is my property being appraised at market value when it should be the ag or timber market value? And then you see the productivity value is here below. This is actually, instead of being taxed on the market value of your land, actually, if you have an ag or wildlife or an eco lab valuation, timber valuation, you're actually taxed on that $975. What the tax assessor collector does is they actually will say the tax rates that each one of the entities charges you times that $975 to come up with the amount of taxes that you will receive or that you will pay. And so what you'll also notice here is that if you had improvements on this property, they would be listed here, and there's personal property that can be appraised and a mineral interest that can be appraised. And then the total market value is what you're looking at with all these numbers added up if you had improvements in personal property and mineral interest. But then the total appraised value, sometimes it says the total assessed value is what you actually pay taxes on. And you'll notice that there's a big difference between last year, which was $975, and $86,000, which is here. And that means that for this I guess was in 2016, but for this year that we did not have any sort of ag valuation applied to this property. So we want to protest this. And usually in the on the notice of appraised value, the protest deadline will be listed. So this had a May 31st of 2016 protest deadline. So that means you've got to protest by the deadline in which you receive the notice of appraised value. There's a couple of other deadlines that we'll go through. This portion of the notice of appraised value tells you the different taxing entities that are going to appraise your property, and then what their estimated tax rate is. Those are usually not set by this time of year. They're usually set in the fall. And then you get what your proposed taxes are. So let me just pause there and see if anybody has any questions.
Yes. Hey, Cassie, actually we do.
Okay.
And this is in the Q&A, if we have animal, I'm sorry, I'm trying to read. If we have an animal in a wildlife exemption, so they must have a wildlife exempt, are they counted in value for taxes? Oh, so if they have animals in a wildlife exempt, I'm assuming on a wildlife exempt property, are they counted in the value for taxes?
The value of the animals, if I'm understanding the question correctly, is not counted. What is counted is land. What is the value of your land? And the way they do that for an ag valuation, really for any open space or exemption that you might see on land, they look at the type of land that it is, and they have categories across the county. So each county has different agricultural categories that might be native pasture or improved pasture, or if you're doing beekeeping, then that has one type of value. Timberland has another type. And so they set a category of land and apply that category to your particular property of what the market value of an ag piece of land that has native pasture on it. And then they tax you on the land itself, but not the value of any animals.
Okay, I think that answers that. I'm going to mark that as done and to the attendee. If we didn't quite get to that, please let us know by sending us another question. Cassie, this may be a good time, and you're going to have to help me navigate this one. This is the one that was submitted earlier. Kind of the differences between the commercial value and his residential property.
Mhm.
I think one of the questions I could surmise is, do they compare commercial properties and residential? Do they make a distinction between the two when they're placing a value on the properties?
They should. It depends on how the property is categorized. So, one thing I do, and we don't have a slide to cover this, but if you go to each appraisal district's website and put in your property ID number into the website, there is a portion of, there'll be like a drop down on the website, and it says like land classification, and it'll have how many acres you have and how they classify that land. So is it commercial? Is it residential? If a property has 25 acres and 24 of those are in wildlife and 1 acre is in residential, then it should have the different categories. So it should have a 1 acre pulled out for residential, 24 acres in wildlife. They'll do the same thing on your improvements. So you can actually, in a more detailed place, be able to see how many square feet they have, how they have it appraised. They don't have comparables like how they've appraised it or the technique that they've used, but they definitely have how your land is categorized. And Mark, you would see that here if this property had a house or a commercial building, it would be on this line here where improvements are.
Okay. All right, so let's leave that one, and we may need to come back to these, and we can also take this offline. One question I think you can kind of answer yes or no, is it kind of normal, was related to this same conversation. Is it normal, or can the appraisal district have such a wide range of market values? For instance, in his area, he was able to find out that it ranges from 13,000 per acre to 160,000 per acre. And that, assuming, I'm going to let you address it, but I'm assuming that's based on what's on those properties and where they're located, that sort of thing. But I'll let you cover that. That's not necessarily out of the norm, or is it?
Well, so the appraisal district, when they're determining what the market value is of your property, there's 2 ways to do that, or 2 ways to protest that. It's your property has to be appraised for its market value. What would a willing seller, buyer be willing to pay for it? And is it being appraised or taxed in a way that's not equal and uniform to other similar properties? So there's kind of 2 different ways you can attack it. You could say, well, the market value of my property is not X, because look at the surrounding market values that are right next to me. Or based upon a similar property, you're not applying the same equal and uniform appraisal technique across. The only way to really understand how your personal property is being appraised is to ask the appraisal district for that information. And typically that happens, at least for us, we will file a protest of the market value or the ag value on a property. And then you're entitled to the information that the appraisal district used to review your property or establish your market value. So the comps. And then you would look at the comparables that they use to come up with your market value and critique those or attack those. And I would ask for that information so that you can do that even in an informal process. Sometimes I know in Hays County, they do that electronically before going to an A or B hearing. So you've got to really gather it. So to answer your question, it's not unusual to have your property compared to other properties, but it's really hard to know how it's being compared unless you know what are the comps that the appraisal district is using for your particular property.
Okay, so that
and bring your own
just,
to the table.
Sure. Sure. It may take just a little more research on our end for that one. And then there's one more question as part of this one, but I think it's going to fall in great with your portion on the actual ARB hearing. So I'll come back to that.
Okay. Let's move through. I think this is just a blow up of what I covered before. So let's look. When should you protest? That's this next section. There's really several types or ways to protest. You have 30 days from the denial letter. So if you applied for ag or wildlife and you were denied, then you have 30 days to protest from that letter. So that letter can occur anytime during the year, most likely in the spring or summer. But if you receive that letter, then you still have 30 days to protest. You also have, there's a statutory deadline of May 15th. So that is just we want you to file your notice of protest on May 15th. And then there's a 30 days from the notice of appraised value. So this gets a little tricky, and I will tell you, I've had disagreements about with appraisal districts about how these rules apply. So give you an example, last year I had a client who did not receive a notice to reapply for their wildlife management in Travis County. And so they realized it when they got a denial letter, and they didn't get the denial letter until late. There was a problem with the mail, so they missed that 30 days, but the 30-day deadline was prior to May 15th. So we were able to protest for the statutory deadline of May 15th. And the appraisal district actually argued, I think they're wrong, but they actually made the argument that that landowner failed to protest timely because they didn't protest within 30 days of the denial letter. It was a denial letter that we never actually got. So there are different ways to protest. I would say, if you get a denial letter, definitely protest within 30 days. You have this catch-all of May 15th. So what we do for our clients that we're representing for Ecolab or wildlife, or if we have a lawsuit pending on those clients, we go ahead and file a May 15th protest of each one of those clients if we haven't heard whether or not they have received approval or denial, and that puts a stake in the ground that entitles us to a hearing. So I would definitely recommend protesting by that May 15th if you haven't heard from the appraisal district.
Cassie, I don't know if you can hear me.
I can.
Okay. This is Rob, and my questions were brought up by Mark previously. And I guess when I brought up the idea of the wide-ranging amounts that the appraisal district is using to assess your market value, if you have a 30-acre residential property that's in wildlife management, and so the taxes on the wildlife part aren't necessarily exorbitant, but the market value keeps escalating. And my neighbor two places over, very, very close, with the same, Highway 290 frontage, they sold this past July, and I've got that sale, and I looked at the appraisal district's market value for their land, and it was like, I don't know, 32,000 an acre, and mine is substantially higher.
Mm-hmm.
And I'm going to use that as kind of evidence, but there's also other properties that, again, are 50 or 100 acres that are across from commercial ventures that are going on that are appraised at 12,000 an acre.
Mm-hmm.
And I guess I just don't understand. When I called the appraisal district and asked how they came up with their value for my property, I was told that they didn't have to divulge that to me.
Well, that's just not
And-
true.
And
So,
that seems to contradict what you just said.
yeah, they are required.
Okay.
I can look at the statute for you. It is through the protest process. So, you know, I would say, well, either I can file a protest and set myself up for a hearing, and then you have to send the information to me 2 weeks before, or you can share it with me now, but I'm entitled to it. You can also send them an open records request. They're a government entity. They're required to comply with that. The problem with the open records request is that they have, I think, up to 30 days to respond, and this protest process is probably going to move a little bit faster than that. So that's why the tax code is really helpful, because once they set you for a hearing, they are required to give you the information that they're going to present at the hearing 2 weeks before. And
Okay.
so what I would tell you, Rob, is go ahead and protest.
I did, and they've given me a date of May 25th.
Okay, then they're in, and so I don't have my property tax book in front of me right now, but there's
Right.
under the tax code, there's a provision that requires them to provide the information that they're going to use at the hearing 14 days before the hearing, or they have to reschedule you.
Okay.
So I would definitely request that information, and I will follow up in an email to you. Like I said, I don't have my tax code here. I'm at the office today, so my tax code's at my handy dandy office at home. So I will, but I'll email it to you, and you can throw that around and cite the code, and that'll make you sound really knowledgeable.
Okay, that's great.
But that should help, because they're required to give it to you, and then it comes in a form of all the comps that they have for your property, and then it allows you to critique those.
Right. And I guess I mean, it seems again, like if I grew up in the Panhandle, but you know, everything's pretty much flat and level there.
Yeah.
And, you know, around here, like I've got 2 wet weather creeks, there's 120 feet of elevation difference. So I guess, you know, if somebody were going to utilize this as commercial, they would have like the Signal Hill project that's right there on 290.
Yeah.
They had to bring in 60 feet of compacted to get it leveled to be usable. So every property around here has its challenges with topography and usability, especially with waterways that might be a part of TxDOT's water drainage issues and
Sure.
or easements. So, I mean, it just seems like, you know, that's
Well,
why
and
I asked them for what they used, and that's when they said they didn't have to provide it.
well, that's just not accurate.
Okay, cool.
So they say a lot of things sometimes that aren't true, but that's not accurate. They have to provide the information that they're using to appraise the property, and
Okay.
you can do that through an open records request, and that just requires them to do more work.
Right.
But you know, they should provide you with the information. So,
Okay, thank you.
you're welcome.
Hey, Cassie,
yeah.
before you move on, I think we had a couple of people that jumped in. I believe we just addressed that with what you just said. One of them was, are appraisal districts mandated to allow you to see the comps they use to determine your open space appraisal? Right?
Not
the same?
not your open space appraisal.
Okay.
This would be for a market value appraisal. You could, by an open records request, ask them for the ag category or how they establish the ag category on your particular property, but
Okay.
that is more specific to the open space appraisal. Those are kind of two different, you know, you have the market value of your property and then what they actually assess under the open space valuation. Two different issues.
Okay. So they're not necessarily mandated to show you that. They would need to do an opens record request to find out how they got to your open space appraisal.
Yeah, I've been pretty lucky in just being able to call up the ag appraiser and ask them what type of ag category they've applied to my client's property. And they usually will share that information. It's usually on the website. So, you know, again, where you see depending on the county, but when you go to the website and you're clicking down on that land, you can see what ag category they've applied. And
Okay.
they have different, each ag category has different market values. So for instance, a timber, which we don't see that very much in Central Texas, but if you're in East Texas, it's that ag category carries with it, the timber valuation carries with it a little bit higher market value because than like a native pasture, because of the market value of timber, how that is sold, and that's a different market value than grazing animals on a native pasture or improved pasture where you've actually planted grasses. There might be a little bit different, like a hayfield, because you're producing income from it. It's based upon what is the income that's being produced on that ag piece of land.
Okay. All right. I think we got to that, to the attendee that submitted that. If we didn't quite get that clarified, please let us know. We'll be happy to come back to it. Or again, we can take that offline. I believe we answered the one regarding somebody else submitted a question about their market value going through the roof, and then about the comps. So I think we answered that. Again, please let us know if Cassie has not. We can come back to that as well. And then the last one, Avalon, you're on the line too. We're going to record this. Obviously, if we send this recording to somebody, can they share that link on their Facebook page with their county citizens tax group? Will they be able to view that as well?
They certainly can. It is a public link that they're welcome to share, and we will be sending out a follow-up email with that information.
Perfect. Thank you. And then the last one.
That's a hard one. I can see the question.
Okay.
The approved degree intensities on a nearby property. Just so everybody knows, a degree of intensity is statutorily defined. How is a property being used to the degree of intensity generally accepted in the area? And that's about the full definition of it. And what it really means is how are other landowners in the county using their land? So there's kind of two different ways the appraisal district or two different criteria. Is your property principally being used for ag or wildlife? Are there other uses that are competing with that use? And second is, are you managing your property as a landowner to the degree of intensity generally accepted in the area? Are you doing, for agriculture, do you have as many animals as a typical landowner might expect to have for a 30-acre piece of property or a 50-acre piece of property? That's where the number of animal units come in. They set those based upon what's typical in the area. It is up to the discretion of the appraisal district to set that, and you can press back on it, but it is pretty typical. You would probably have to obtain that information of what a landowner adjacent to you, or what is a degree of intensity by an open records request. That is not something that you're typically going to get in a protest process. But again, they're government agencies, so you send them an open records request, they're required to give you that information.
Okay. As a landowner is up in Mason County, is it safe to assume that if the neighboring nearby property is similar to mine in habitat and everything, that the degree of intensity should be relatively close to the same?
It should be.
Okay.
It depends on, do you have similar grasses? Can your property carry the same animal units? If it's in wildlife, then the degree of intensity is really set by statute. You have to do 3 activities each year in order to qualify for wildlife. So that degree of intensity is a little bit better defined than like an ag valuation.
Okay. Well, then we're gonna close that one up and let you continue, guys. Please, to the attendees, don't hesitate to continue asking the questions if we need to further clarify some things. Thanks, Cassie.
All right. So the next section is, how should I protest? And we're going to walk through a notice of protest. So see this. This is a notice of protest form that you'll file when you're filing your protest, and this is a statutory form that's generated by the comptroller. And I'm going to highlight this section because this is the most difficult section for a lot of landowners to fill out. So when you're filling out your notice of protest, you've got to basically check these boxes. And so I'm just going to walk you guys through which each of these boxes mean, which is incorrect appraised or market value. So this would be, I don't believe my market value is correct. I think you've done it wrong, appraisal district. The value is unequal compared to other properties. So that's the difference. Those are like the two different ways they appraise property. Those are the two different theories. So it's not appraised according to market value. So I have a comp that shows that sold, my property is very similar. So you've done incorrect market value, or you've appraised mine unequally compared to other properties. So the value is unequal. It's a little bit easier, let's say in a commercial situation where you've got buildings right next to each other, or an apartment complex, or a residential use within a subdivision. Sometimes the unequal is a little bit easier because you can compare a little bit of apples to apples. It gets harder to make that argument when you're talking about raw land, but can be made. It just takes a little bit more data. This one is property should not be taxed in this particular taxing unit. If you are, maybe you're being taxed by a municipal utility district that isn't serving you, or a school district that isn't serving you, and they made a mistake. This property is not located in this appraisal district. So this doesn't happen very often, but I've had clients where the surveyor of their property doesn't match up with the appraisal district record. So maybe, 10 or 15 acres of it should be in another county, and they're trying to correct that. This is a really important one. A failure to send required notice. So if you ever fail to get a denial letter or a notice of appraised value in which you can protest, you actually can file a protest that says you failed to send me the notice, and this is why I'm protesting. In fact, landowners who are over 65 are required to get special notice of a change in use of their property if their ag is denied, and you would protest that. So there's lots of issues on the failure to send required notice, and especially that happened in 2020. I hope 2021 will be different, but I had a lot of landowners not get notice of their either appraised value or their denial notice last year. So a lot of people use the word exemption. An ag valuation is technically not an exemption. An exemption is I don't pay taxes at all. So that would be some like a charitable exemption, or some, just like a religious exemption, those kind of things. There are exemptions from paying taxes. And so a lot of people check that, but it's technically not right for an ag use. The ag use is up here to the right. Ag use, open space, their other special appraisal was denied, modified, or canceled. And so that's the one you would check. A change in use means under the law that you changed the use of your property. So technically that tends to mean your property was developed, or you went from ag use to commercial use or residential use. When I'm protesting, I usually check the ag use open space was denied and a change in use, just as a protect all for my client, to make sure that we're protesting because I'm worried about a rollback on that change of use. But if you're just dealing with the rollback and you're protesting that, the change in use would be what you would protest. This is the incorrect appraised or market value of land under special appraisal. So you would protest this if you think your ag category is incorrect. The market value of your ag land isn't, I think somebody posted, $4,000 an acre. It's really $2,000 an acre. That's what you would protest. This is owner's name is incorrect, property description is incorrect. This can be, if they don't have a property ID number that should be in there, or if their mapping is incorrect, you would do that. And then we won't really go into this, but there are certain exemptions for disaster damage that I don't really deal a lot with, but there are exemptions for that. All right, so once you file your protest, you're entitled to appear before the Appraisal Review Board. And it is a panel of landowners or homeowners that are in your county. It can be 3 or 5 of those, and they hear all the protests in the county. And when you go into that hearing, they are sitting in a panel. We did a lot of remote ones via Zoom last year, but they're a panel that hear the appraisal district side of the story, and you get to present evidence about your side of the story. So once you file a protest, you are entitled to a hearing. Sometimes, depending on the county, it can take a few months to get that scheduled. You are allowed one opportunity to reschedule. So let's say, as a landowner, you would have a doctor's appointment where, because they just assign you a hearing date and a time. Then you're allowed to contact them and say, hey, I can't make that date. And they will allow you one reschedule. It's fun to note, or it's funny to me to note, that I'm not allowed one of those. So as a property agent, I don't just automatically get a reschedule. I have to really show that I have another hearing or another ARB hearing. So landowners are especially afforded that. So I'm just making a point here. Once you filed your protest, if you're not getting a hearing within a few weeks of filing that protest, I would follow up with the ARB and make sure that you're getting that that set. And sometimes I use, the Appraisal Review Board is quote unquote independent or separate from the appraisal district. So, one of the things we do at the firm is we will protest any applications that we've submitted that haven't been reviewed or decided by May 15th. We will file a protest for all of those. And then we start the ARB process where we're getting hearings set up. And then it gives me leverage because I may get a hearing and the application for my ag still hasn't been approved. And I can then call the ag appraiser and ask them to approve the application because I got a hearing next week. And it's a way to kind of triage that to get them to answer a little bit faster. But you want to make sure that you're getting a hearing and that you're ensured a hearing. I talked about this a little bit earlier, but the evidence packet you can obtain 14 days prior to the hearing. So everything the appraisal district is going to submit, you're entitled to see. And you should bring your own evidence to the hearing. The Appraisal Review Board, in my experience, they spend a lot of time with those appraisers. So even though they're landowners or homeowners, they definitely give the appraisal district the benefit of the doubt, and you need to be prepared to bring in your own evidence to the hearing.
Hey, Cassie, a follow-up question to that last bullet about the evidence. Can you give us a little example of what type of information may help me or a landowner actually get a lower value?
Yeah, so if you're protesting market value, I would use, as Rob mentioned, a recent sale that you may, what you may not realize, or what a lot of lenders don't realize, is that the appraisal district doesn't really know what properties sell for, because in Texas, there's no sales disclosure. So they're relying on rumors or things that they've heard. So you may have more up-to-date information about comps than they do. And so, giving them that one thing, I personally protest I have a property tax consultant that protests my appraisal, and I bought a new house in 2018, and my appraisal of my property was less than what I paid in market value. So we didn't really touch it. But this year it was above what I paid in market value. So we're going to take in my sales data to say, no, 2 years ago I paid this for this house. We want you to reduce it. The other thing you should know is if you have a homestead, like a residential property and you live there, it's only allowed, your assessment, not the market value, but what you're actually assessed on can only go up 10% each year. So there's a cap on what it can increase. So you want to be watching that. So any clumps, anything that's unique about your property, any, a portion of it doesn't have access, or it's not really that developable because of the topography, bringing all of that information in, what the market value might be. So some people will get like an appraised value from a broker that just says, if I were to list this property, this is what I would recommend it being listed for. And if you can get that, that's less than what the market value is, or what the appraisal district sees as the market value, that can be helpful. On an ag or wildlife protest, what you're taking in is really demonstrating the use of the property, the ag or wildlife management use of the property.
Thank you.
All right, let's go on to the next one. So this is the ARB process. Some common mistakes that I see is you file a late protest, so you don't file it timely. And so one of the questions that the ARB asked at the very beginning was, this protest filed timely? Or the appraisal district might say, well, they didn't file their protest timely, so actually you don't have jurisdiction to hear it. On a failure to receive notice, I had a client a few years ago, did not get notice. It went to the wrong address. We can demonstrate that. The appraisal district just has to demonstrate that they put it in the mail. They don't have to make sure that you received the notice, even if it's a denial. That really stinks from the statutory perspective, and really relief for landowners. It's really hard. So if you're filing a late protest and you're waiting on a hearing, you still owe the taxes, or at least the portion that you had maybe to pay last year. So under ag or wildlife, let's say your ag or wildlife was removed and you are waiting for a hearing because you filed a late protest, you still have to pay the taxes on the ag or wildlife amount, or you're not entitled to a hearing. So those delinquent taxes that come due January 31st are super important. It will erase your administrative remedies, both in the ARB and a lawsuit, if you're not paying those on time. The other thing to notice when you're in that ARB hearing, this happens to me a lot. There's a panel there and they've been trained, but they don't know the law as well as I do, because they haven't been doing this for years, and they may mess up on a procedure that they should be doing. So, you want to make sure that you're getting a decision on the thing that you protested, and you need to bring it up with them and make sure you're getting an order. I had a client this last year that had a market value dispute, and the hearing clearly, when you go back and listen to the tape, it's always recorded, they heard both property ID numbers in the hearing. But when the order was issued by the ARB, there was only one order covering one of the properties. And so the appraisal district is now arguing in the lawsuit that we filed against them, well, there's not an order for this other property, so the court doesn't have jurisdiction to hear it. And we're like, wait a second, we went through an ARB hearing. They discussed both of these R numbers. It's a failure on the Appraisal Review Board's part to not issue the correct order. So there's just little technical gotchas that you want to make sure that you're, make sure you get all your issues heard, and you want to make sure that you're getting an order. And then,
Cassie?
Yeah, go ahead.
Can I just ask, if you go to this hearing, you present your evidence, when will they give you this order? When does that occur?
It really depends, Rob, on how busy they are. So you should be following up. And what's really crazy about it is like what I saw this last year. I would have the hearing in February, and the order would be signed of the day of the hearing, but it actually wasn't sent until like a month later.
So
And
when
so-
you're at the ARB, you have no idea what, you've given your presentation, they've heard it, they've asked questions, and then you leave. Not
So
knowing-
they make a decision right then.
They make a decision on what they're going to do.
Yes, so
and
they'll
it's
take a
gonna be
vote.
Shared with you.
Yeah, they're in front of you, they take a vote. And you will hear the decision. They'll make a motion. It's kind of like, they'll say, after hearing the evidence, I make a motion that we deny this request to change the market value and that we set the values that the appraisal district set. Do I have a second for my motion? And somebody will second, depending on how, and then they'll do their ayes or vice versa if they approve it. So you get to know right then, but the physical piece of paper that comes in the mail to you, you may not receive until after a month, 2 months, few weeks
Okay.
after that actual hearing date.
And after they've made their decision, that's final.
That's final, yes. So you can appeal it, and your opportunities at that point, there is an arbitration process if the value is over $1 million and it's a market value issue, there's an arbitration process, a binding arbitration process, or you can file a lawsuit. But the lawsuit must be filed within 60 days of actually receiving the order.
Okay.
So that's and I haven't done many of those binding arbitrations because we deal mostly with properties that are in ag or wildlife. And I don't like binding arbitration because I would rather file a lawsuit and negotiate it. So with the appraisal district.
Okay, thank you.
All right. I think we've got a question here, Mark, that I'm seeing. Do you want to answer it now?
That's entirely up to you. If you're ready to go ahead and take care of that one. I think it's applicable to some of the other discussions and a very practical question. They're just kind of stuck and they're not sure what to do next.
Yeah, so this landowner rate or homeowner, last year the ARB told me they used sales to get my market value, but my market value is significantly higher than other houses on the street. I showed them those comps, but they didn't seem too interested in that. Wouldn't that be one of those unfair assessments? Yeah, I agree. It would be unequal and uniform, that they're not appraising your property the same as they're appraising other people. And you would have to show how your property is similar. Because what they're going to present is, well, we know that yours is a 2-story and that you've recently updated it, and yours has this brick on it, and the other comps that you're showing us, they don't have brick. And so they're, so you got to be able to say, well, this house is very similar. So you want to, like, if you live in a neighborhood, you want to find another property that looks like yours on the outside and try to look at what their value is, because they are required to do an equal and uniform appraisal. The other thing that I would mention is don't ever invite them into your house. I had a client a few years ago, probably like 10 years ago now, and she just was being friendly, and they came out to inspect her ag or wildlife on her property. And it was hot, and she was like, oh, let me get you some lemonade. Let me, step right inside. Well, they had recently done some renovations to the inside of their house, and they had new granite countertops, and they had built-in bookcases and really nice things. And lo and behold, the next time that, so it was the ag appraiser, and the ag appraiser took pictures of the interior of their house and submitted those to the residential appraiser, put it in their database, and the next time that the appraisal came out, their house was increased in market value, and they had data to prove it. So they're not allowed on the inside of any building. They can measure the outside. And so, don't ever let them in. Even if you're
Great. I want to tack on to that one real quick. This is just a practical question for me, seeing this last question. When do you recommend a person enlist help? Whether it's your help, whether it's something else. When should somebody ask for help in these situations?
Well, I always recommend, you really our firm is a law firm. And so well, I do protest ag and wildlife situations. It's usually when the client it's not a typical situation. The client is really in a lot of trouble. They need a lawyer. They know that it's going to go to lawsuit. They're kind of in hot water. They didn't protest on time. We're having to do something special. That's really when you would call me. Plateau helps out a lot of landowners that just got their wildlife denied, and it needs to be worked out. And I work a lot with Plateau to get clients reinstated. So, losing your ag or wildlife is very, that can be difficult. And depending on the situation, I would say, let's talk. And usually in ag or wildlife denial, we will either get involved or we'll have Plateau handle it depending on the situation. And if it's a market value, I recommend using, at least initially, a property tax consultant. They are usually former employees of the appraisal district, and they have a lot of data. And what's great about them is that they will share their database with other property tax consultants. And so you're more likely to be able to get comps along 290 or something in your neighborhood because they can analyze the data and know where to pull the strings. You want to call me when that doesn't work and you want to file a lawsuit, or you're seeking some additional relief. But a property tax consultant, and we have a few that we recommend in different counties, they can really handle that. That's what I personally do, is I have a property tax consultant that just files a protest for me every year, and we can always back out of the protest. So
Great, that's perfect. Thank you.
And if you want recommendations, I don't have my Rolodex in front of me, but email us, and I'm happy to get you connected. Again, depending on your county, there are different people that specialize in different counties.
Cassie, I don't mean to ask so many questions.
That's okay. No, Rob, it's better than me doing all the talking. So.
Well, okay. So if you are in wildlife management and the actual taxes that you owe are not high, but this market value keeps escalating at, just an explosive rate. I mean, the reason I'm thinking I should be protesting it is the rollback taxes, or if I were ever denied the wildlife exemption, all of a sudden the property taxes would be such that I'd have to sell. I mean,
yeah, okay. I agree with you. So I would definitely, because I know where your property is, I would definitely tell you to protest and try to get that value down. You're just in a really growing area, and and understanding that is really important. The difficulty you'll have so typically a property tax consultant is going to take a percentage of what they save you, and they're not going to save you anything, right? Because your value is already set at wildlife. So you're going to have to, if you wanted help from someone, you might either hire them on an hourly basis or have them do a flat fee for you to do the representation, because you need kind of the extra help on the comps, but it's outside of their framework of how they're typically paid, if that makes sense.
Yeah, exactly. Okay.
Yeah.
Thanks.
I think you should definitely protest it. It's not going to hurt.
Yeah.
I think you may have just answered this question that popped up. Should the market value of land that's under ag or wildlife valuation be protested, even if the taxes are low because of the favorable valuation, but there's still the market value piece? And I think the advice is yes, to watch that market value closely.
Yeah, it's going to be the rare situation, but let's just say, next year you don't get your notice of appraised value and you forget to look for it, or you don't get the denial letter and you don't protest. Well, the appraisal district is going to say, so sorry, we put it in the mail to you, and you can say, hey, I didn't get it. I didn't have an opportunity to resubmit. And they deny your wildlife management or ag or whatever, and you're working to get it in place. You're going to pay full market value taxes for that year, unless there's some, extenuating circumstance. And call me because there's some solutions there. But you know, that's what Rob and I were talking about, is something happens and you lose it, even temporarily, you would pay market value. And so you need to keep that market value down. But a lot of landowners who have an ag valuation don't do that because they're just not worried about it because their property taxes are so low currently. But you want to watch that market value.
Exactly. And then I think if I understand rollback correctly, rollbacks for the most recent 3 years, correct? So the value, the most recent 3 years.
Plus interest. So
Plus
it can be
5% interest.
Yeah. So that is a change in the law. It went from 5% to 3%. I mean, sorry, 5 years to 3 years. Last legislative session. So that's a little bit better, but there is a large rollback tax that you will pay if there's a change in use of the property. We argue that it has to be, you would have to be developing your property and changing the use, not that you didn't qualify for ag or wildlife. So that is something to be protested as well. If they instituted rollback on you because you didn't qualify for ag, you can protest that and say, well, yes, I didn't qualify, but I didn't change my use. I'm still using it for wildlife or ag use.
Great point.
All right, so the next slide is, what if I fail to protest timely? So really this is really fact intensive. So did you get are you over 65? It gives me a lot more options if you are. There's this portion of the tax code that requires additional notice. Did they send you an annual report request and you failed to submit that? Then that's a different situation than failing to submit an application on time. What I tell landowners is, just remember, you may fail to protest a denial letter, or, maybe you didn't get the notice that you needed to reapply, or that you needed to submit an annual report and they remove your ag. But if you have not gotten your notice of appraised value every spring, you need to be looking in your mail and calling the appraisal district for that. And that always comes out in April or May. So just know in your brain, hey, every April and May, I should be getting a notice of appraised value, because if they have removed the ag, they will typically do it on that notice of appraised value, which will trigger an opportunity for you to protest. So just always be looking for that notice of appraised value and make sure you're reading it correctly. If you have problems reading it, please call me, and I'm happy to walk you through it. So you can file a late protest. It's got to be that you failed to receive notice, or sometimes you can do it very late if there's a clerical error or a market value. It's really hard to file a late protest for ag or wildlife removal. There is a section of the property tax code that allows you to do it, a protest, if it is the change in your valuation would be 1/3 of your market value. So there's some technical issues there, but it allows you to do it late on those circumstances. But regardless, you need to file your protest prior to the tax delinquency date, because it's really hard. The statute just doesn't contemplate allowing a protest after January 31st for the previous year. All right. Any last questions? While we're waiting to see if anybody has any questions, I'll also just mention our property tax calendar. We did this for all of our clients this year, send it out in January, February, and it's meant to just kind of give you some parameters. These are the things to think about. If you'd like a copy, if you didn't get a copy in the mail, happy to send one to you. either mailing it to you or send one to you electronically, but it has all the big deadlines on it.
I do have one question. You said about this evidence packet that you can have access to 14 days prior to your ARB hearing. Who do you contact? Because if you call the appraisal district, it's hard to get anybody on the phone. And emailing them, I've found that I emailed my protest and I never heard back that they had received it. So it's a little hard. Who do you know who or how to get that?
It would be that, whoever's handling your, I would send it to the Appraisal Review Board, Rob, but because you probably aren't going to know who's handling your, the person handling your protest. You usually aren't assigned that, or if you know that appraisal district employee, you can ask them for it.
And
But it's usually sent to the Appraisal Review Board.
the informal where you try to resolve it before the ARB, is that, how do you, I mean, if you want to see if you can just walk through it with somebody.
Yeah, I mean, you can ask that appraiser for the information, and sometimes they'll share it with you. But we usually send that request once we get a hearing date. We send that request to the ARB, the Appraisal Review Board, and they forward it to the appraisal district.
Okay.
And we send it in a letter form. But I'm also trying to document, I'll send it certified mail, and I do it really formally because I want to make sure that they are seeing that I know that they've received it.
Right.
So I think we had another question.
You may have already, I think you may have mentioned this earlier. If they haven't received their notice, they should probably do both, call in, protest, or at least call.
I agree. The protest deadline for statutory wise is May 15th, which this year is on a Saturday. So, I would definitely protest. Because you can always not show up for the hearing or just withdraw your protest.
Okay. And then I'll let you review that last one that came in to see if you can tackle that or want to tackle that on this.
I don't know the building code. You would have to probably get that from the appraisal district of what those building codes mean. That is something super specific, probably to the appraisal district of the way they've classified your particular residential use. They have different codes that they use that allows them to, if they're coding your property a certain way, then other properties that are coded that certain way it'll be more uniform in the appraisal. So I don't know about that particular one.
Okay, so contact the appraisal district.
Mm-hmm.
Okay.
All right.
All right.
Here is our contact information. So my contact information, Mark's contact information, please feel free to reach out. This is the time of year where we get a lot of questions about property taxes. Happy to share this presentation with anyone. We, as we said before, we're recording it. We'll have it up for people to view as well. So pass it along. Happy to answer questions. We want to be a resource for landowners. If you haven't signed up for our landowner alert system, we have a newsletter that talks about not only property taxes, but other things affecting rural land. And we feature a lot of blogs from our attorneys or articles. It's a really great newsletter to kind of keep you informed as to what's going on. And I appreciate everybody's attendance and all the great questions. That makes it so much more fun than me just droning on and talking about property taxes.
Thank you, Cassie. It's been great. And to reiterate again, the recording will be sent to all the attendees and even the folks that didn't attend, but you will receive it via a link. I'll touch base with you, and that's another opportunity for you guys to communicate with us. So we're here and available, and thank y'all for attending. Cassie, thank you again for the great presentation.
Loved it. Love to do it again. Thanks, guys.
Bye-bye.
Bye-bye.